The following program was produced by the United States Courts.
We have a wonderful, distinguished panel this afternoon to talk to you about the federal defense effort, challenges, choices, and commitments. And let me just introduce briefly our panelists. Immediately to my right is Paul Larkin from the Heritage Foundation. He's in the Legal Studies program there, where he's a senior fellow. Welcome, Paul. To Paul's right is Chief District Judge Catherine Blake from the District of Maryland. And in addition to being the Chief District Judge, she's also the chair of the Defender Services Committee for the Judicial Conference of the United States. Welcome, Judge Blake. We also have Tony Ricco on the end, not last and not least. And Tony is a criminal justice panel attorney in New York. He's been in practice for 30 years on all types of federal criminal cases. And welcome, Tony, to the panel. And then seated just below me is a living legend, Terence MacCarthy. He helped create the very first federal defender office and was very active on the amendments to the Criminal Justice Act in 1970 that created our federal defender system. So, Terry, welcome. Looking forward to hearing your remarks. First question, and sort of taking a lead from Kathleen Kennedy Townsend. Judge Blake, have we lived up to the promise of the CJA, the goals of the CJA? And what do you think Robert Kennedy would think about today's federal defender program?
Well, I'll start with the short answer. I would certainly hope that he would be delighted with how the Criminal Justice Act has worked out over the past years. Just even before I say that, though, I do want to mention I'm delighted to be here. As in addition to my hat as chair of Defender Services Committee, I am right now Chief Judge in the District of Maryland. I both live and sit in Baltimore. So if I'm a little tired, I was up late last night. I echo the comments, and I just wanted a chance to say that I certainly hope the very unfortunate violence that we have all been witnessing or seeing on the news does not make us lose sight of the many important questions that motivated what were peaceful protests very largely up until last night. So I echo those comments that I hope we will keep our eye on what's important in the issues in Baltimore. Excuse me. So in terms of the Criminal Justice Act, I think that what we have today is if Clarence Earl Gideon were going into a federal court today, or like most of the defendants that come into the federal court system today, they cannot financially afford an attorney. And what that means is they get the gold standard. They get the best quality of federal defense representation that I think you're going to get, whether it's from a federal defender office, from a community defender organization, or from our panel of very well qualified and experienced panel attorneys. I know in Maryland, excuse me, and I think it's true in most districts, we have a panel application process. It is not, as the Lieutenant Governor mentioned, the system where you sort of just pick somebody out because they happen to be in the courtroom. People apply. They show that they are experienced. I think it's an honor to be on CJA panels. I hope it's perceived that way. So I think we've come a long way. We're providing great representation. And I'll say just briefly, personally, I've never been a defense attorney. I have been a prosecutor. I was for a number of years, and now a trial judge. And as I think Mike Nachmanoff mentioned at the beginning, whether you're in it as a prosecutor or as a trial judge, you recognize very quickly how critical it is to have experienced, well-qualified, appropriately resourced counsel on the other side representing the defendants. So I hope that Robert Kennedy and the rest of the Kennedy family would be very happy with where we are now.
Thank you. Paul, I wonder whether you have any reactions to that, also a former Justice Department attorney and somebody who works at the public policy level. Reactions?
I think it's unfortunate that the high quality we have of public defenders and CJA attorneys is not as well known in the community as it is. It is known within the bar, and principally within the criminal justice bar. As the judge said, when you get a lawyer appointed to you, say here in town from the Federal Public Defender Service, you're getting someone who has all the academic credentials and all the practical experience and all the savvy that you would want to have in a lawyer. You have somebody who knows not only what the law is substantively and procedurally, you have somebody who knows who the opposing pitcher is, if you will, and then you have somebody who knows who the umpire is and has to try to put all that together. You're going to get as good, if not better, quality representation than you're going to get if you went down and hired somebody from one of the large, prestigious law firms in town. The sad thing is, the people in this room know that. The judges on the bench know that. The people within the criminal justice bar know that, but the average person doesn't. And so to some extent, he would be happy to know that the system has worked by getting good quality people, but he probably would be disappointed in that the average person wouldn't realize how good a job those people do.
Thank you. So I want to sort of segue into, there was a comment earlier about the impact of the sequester in 2013, and I want to switch gears and talk a little bit about that and the impact on the federal defender program. We know it was quite devastating, and we're still rebuilding. And Terry McCarthy, I want to ask you, what have we learned from that experience? How can we protect funding for the federal defender program in the future?
Well, can you hear me here? I've got to, okay. I'm not the one to answer the political issue of what can be done, although I've heard somebody on our panel do a pretty good job at it. But the sequestration was horrible. It was ridiculous. The Congress is picking on these federal defenders who are the gold standard, as Kathleen said, and everybody else up here said, and they're reducing the budgets. So many people were fired, laid off. We had a defender in Ohio, a very good, competent defender who ran a wonderful office. He couldn't see his way to firing any of his staff. So what he did, he quit himself to open up that thing. That sequestration was horrible, and it affected us. By the way, it didn't affect the Department of Justice. We're going to prosecute people, but we're not going to defend them. What can be done? I don't know what can be done. I have no political ideas, so I'll leave it at that.
Thank you, Terry. Tony, if you could just respond as a CJA panel attorney about the effects of the sequester on you and your colleagues.
Well, anytime Congress decides to withhold funding from essential services, people are impacted by it. When Congress does it in this circumstance, it does it with people whose liberty is at stake. And so you don't take a time out for the prosecution, but you're taking a time out for what the defense does. And that includes maintaining a relationship of trust with the client, providing services. So the impact was devastating. It's the type of thing that should not happen. I mean, if there is an area that we say, you know, we don't touch that, we leave politics outside of that. The representation of indigent people, the delivery of services in the court, ensuring that the court runs effectively, should be one of those areas.
Thank you. And Judge Blake, you know, putting on your chair of the Defender Services Committee hat, you know, you were running point at that point, and if there's comments that you've got about sort of where we are now and how far we've come since then.
Well, yes, I had great timing. I got to become chair of the Defender Services Committee in the fall of 2012. 5% funding cut hit, and then in March the sequester hit. So it was a great ride, and we're still going. One thing I will say is that while I certainly agree that it is unfair and unfortunate for funds to be withheld from any essential service, and certainly from defenders, I found, and I think a lot of, again, people in this audience found in advocating the cause with Congress that, in fact, there was a great deal of bipartisan support for this particular function. The defenders, very unfortunately, and panel attorneys got got caught up in a political fight that was a lot bigger, had a lot of other issues beyond criminal justice, and that was unfortunate. But we got very good response and recognition, again, from both sides of the aisle in Congress. We did ultimately do reasonably well with Congress thanks to that advocacy. And as I say, I think that the Sixth Amendment, the recognition of the importance of the Sixth Amendment is something we can see across the spectrum in Congress. So I hope that's going to continue. Predictability and stability of funding is critical.
Thank you. So in terms of structural issues with the current system, how do you respond to people who are concerned about the independence of the defense function and say that defender services shouldn't be within the judiciary? What are the advantages and disadvantages? And what are your thoughts on different levels of independence? So, Terry, let me come back to you and have you answer that question.
Sure. The American Bar Association standards for providing defense services very emphatically state that there should be no judicial influence at all or involvement in defender work. I've known that, lived with it for almost 50 years. There's a problem with it, however. It sounds good. I think in the main it makes sense. But for instance, we have had the committee, which the judge so ably now chairs, we've had that committee from the onset. As a matter of fact, the Criminal Justice Act we're talking about today created that committee. And John Hastings, a wonderful, wonderful judge from the Seventh Circuit, was the first to chair it. And let me tell you, I'll shock you all. The defenders, and now I think I know I speak for a majority of them, but the defenders get along with that committee. We've had no problem with them. That committee has in no way sought to influence the way we practice law and do things. If anything, it's helped us. It's given us, Chuck Arberg just walked in here. He came out of one of the afternoon bars, no doubt, but...
Hey, that's my colleague, be careful.
But Chuck just walked in, and his efforts and the efforts of the Federal Judicial Center are ours. Our federal defenders are the best trained defenders in history. We get wonderful training, excellent training. And so we have had a good relationship with that committee. And I share with you one quick observation. Some years ago, there was matter of fact, essentially what they're going to be doing again now, but there was a report issued on the federal defenders entitled the Prado Report, named after a distinguished Texas judge. It was a well-researched, excellent report. That report specifically recommended, in obedience to the ABA standards, no doubt that we be removed, or that committee that the judge chairs cease to exist, okay? You want to know the interesting thing? I was amazed, happy but amazed, and a large majority of the federal defenders said no. We don't want it. Leave us where we are, because that committee has done nothing but help us over the years. Now, are there problems with judicial influence? Yes, there are problems, but they're not at that committee's level. They're in the trial courts and even in the Court of Appeals. In the Court of Appeals system, I don't like, although I've got to tell you it's worked out all right, but the Court of Appeals judges are the ones who select the federal defenders, not the community defenders, but the federal defenders. But the problem is, they've done a darn good job of doing it over the years. They've appointed committees, but that's obviously a judicial problem. More so, at the district court level, there are problems. If I were Plato's philosopher king, I would make these changes or suggest them to the judge and her committee. We don't need Congress to do this, they can do it. But here are the problems I see. First of all, who selects the panel attorneys? Oh, it's done exceptionally well in many districts, but in some districts, it's not done very well at all. The judges are picking the panel attorneys, and I can think of an infamous case where they did just that and screwed up the case, but I won't go into that one. But anyway, once they pick them, the lawyers to be on the panel, who is it that selects the lawyer for appointment? Some places it's judges. Now, I happen to come from a civilized community in Chicago, and we have a phenomenal system. The judges have nothing to do with selecting the attorneys. I commend that to the committee. The judges have nothing to do with picking the individual lawyer who's going to represent the defendants. I think they should be taken out of that. There are also problems, and then I can shut up, with the judges okaying requests for expert services. It shouldn't be that way. That's letting the judge and our adversary know who our experts are going to be. It's not fair. And finally, they are the ones who rule on the appropriateness of the panel attorney's voucher. I think we could do work with the panel attorneys, but good gosh, let's leave the federal defenders alone. We're in great shape. We're proud of what we do, and we've got a wonderful history and a great group of young men and women who are, and by the way, diversity, women, wonderful. Look, I don't know how many, but how many women are heading up federal defender offices today? It's incredible. It's wonderful, okay? Shut up.
Thanks, Jerry. Tony, the subject of Criminal Justice Act panel attorneys came up, so let me turn to you. I imagine you have some comments about that.
Well, sure. I think Terence nailed it, though. We have a fabulous system. To use Baltimore as an analogy, things come down to relationships. And I think at the heart of the relationship, the successful CJA panels, the successful federal defender offices, exist in those jurisdictions where there's a strong relationship between the judiciary and the panel and the process, where there's a healthy respect for the information that the lawyers share with the judiciary and vice versa. The results have been phenomenal. Terence hits that solidly. There are three areas where we see difficulty, and Terence hit each one of those. One is access to services. That's a difficult call for the court, because the court is now stepping outside of the judicial function and into the defense function when it does it. But there are many judges who ask questions about it, and then there are those districts where the judges don't authorize the appointments regardless of the submission. That's a problem. We also see it with respect to selection of panel members. There are districts where the judges select the panels and they're reflected in the quality of representation and the type of people who apply to the panels. And then there are other districts where the responsibility for selecting a panel is shared, but the burden of it is really on attorney participation approved by the court. And we see a different level of interest in the panel, a different quality level, and a more successful panel. The other issue comes to voucher cutting. Mm-hmm. And that's a very dangerous area. A judge says, you know, I'm going to reduce a voucher in this case. And they say, okay, I'm going to cut that voucher $2,000. Well, why not $1,500? Mm-hmm. Why not $2,500? A judge will tell an attorney, I'm not going to authorize payment for any work that you did more than 10 hours a day. Well, that's putting a restriction on the defense function that doesn't exist for the court, nor does it exist for the prosecution. And so while, whether or not we should be under the judiciary or not, I don't know how I come out on that.
Yeah.
I'm not one to venture into the unknown when what I have is working. But these are areas that we can look at to improve upon what we have and to ensure that we're still delivering that high level of representation. And in those districts where you have a strong relationship, those three issues are resolved. And in the districts where you don't have that strong relationship, those three areas highlight the tension and exacerbate the issue of whether or not we need to be out from up under the judiciary in the first place.
So the challenge on those three issues is how do we improve the consistency to keep the quality at a high level?
The bottom line is that we should be maintaining a high level of representation, and we should be changing how we do that in order to maintain that.
Got it.
If staying under the judiciary means we're eroding that, then it's time to make changes.
Thank you. Paul Larkin, I know you've got some comments about where the defense function fits, whether it should be within the judiciary, some other structural changes. Your thoughts about that?
Sure. I think the problem can be analyzed in a variety of different ways. One way to look at it is macro versus micro, and another is to look at it as trial versus appellate. Mm-hmm. Start with the macro. If the defense function is part of the judicial system, you have the umbrella and the authority and the general good feeling that a political body like Congress will have towards the courts benefit the defense bar. Mm-hmm. It is just a factor of politics that courts are going to enjoy far more respect from the general public than defense attorneys. And therefore, that's going to be reflected in how politicians act when they're allocating funds. The problem with that is, however, whenever you are not fully in command of whatever it is you're trying to do with any legislative body, you lose some control. And somebody else, therefore, can make the types of trade-offs that you might not make. That can be good, that can be bad, but it does deprive you of a little bit of control in this regard. Now, as to dealing with this at a micro level, if you wanted to deal with some of the problems I think some of my colleagues have talked about, perhaps what could be done on a trial basis in different districts is to allow a committee, perhaps composed of, say, a former judge, a former defense attorney, and a former prosecutor, make the decisions on the vouchers and the like, so that you don't have the trial judge making these sorts of calls. You have them made by professionals, and those are three professionals who would represent the three relevant parties. And it would be similar to what happens in civil rights attorney fees awards, where a plaintiff's attorney who wins can present to the trial judge affidavits from different lawyers saying what the amount of work would have been, what the time would have been, the different needs, the compensation, et cetera. Maybe in the short run you would need the judge to be able to have the final authority over this, but it'd be worth trying out to see how three other people would respond to these sorts of issues, because it may well be that in the long run, having somebody else like that serve for a finite period of years and not be reappointable, if you will, so there's no question of whether or not somebody is trying to avoid angering someone. Do that for a while and see if that works. Now, trial versus appellate, let me focus on the appellate. Mm-hmm. The federal government has different divisions within the Justice Department, and it has one in particular, the Office of the Solicitor General, where I worked, that is responsible for representing the United States in the Supreme Court. There isn't a comparable defense office, and maybe it's time to create one. It could be done rather simply, even just on a trial basis. You could take the Federal Public Defender's Office here in town, give them 5 or 6 other lawyers, and perhaps their focus would be not on all of the cases where someone is asking the Supreme Court to take it, not at the petition stage, but later at the merit stage. There are an enormous number of cases where you have amicus briefs from a variety of different parties, but the quality of the lawyers at PDS is so good. Having amicus briefs from those lawyers taking the defendant's side in a lot of these cases would, I think, provide a valuable counterpoint to the quality of the representation that the United States gets from the Solicitor General's office in the Supreme Court. Now, that's a small change, and maybe it is, even though small, too audacious for the federal defenders to try to push, because their real concern is dealing with lawyers at the trial level, which is entirely understandable. The percentage of cases that get plea bargained is between 95 and 97%. So the number of cases that go up to the Supreme Court is minuscule rather compared to the overall number of them. And perhaps what you really need are more good negotiators down at the trial level than you need people who are appellate skilled lawyers at the upper levels. That's something that only within the federal defender system they can make that sort of call. But like I said, maybe that's the sort of call they can make better than people who are representing the judiciary. And so maybe they can try to see if that sort of system works for them or something else. So you have macro and micro ways of looking at this. You have trial and appellate ways of looking at this. Whichever way you look at it, I think one of the important things to try to emphasize and persuade people of is the importance of making sure that each side gets 4 downs, each side gets 3 strikes, however you want to look at it. If you have a system whereby there are more assets in play, personnel, dollars, experts, et cetera, when the government shuts down completely, then when there's a sequester, there's got to be something wrong with that. We know that the government treats various personnel as quote unquote essential, and they are allowed to continue to work if the government shuts down entirely. I mean, the Bureau of Prisons, for example, doesn't say that to all the prisoners, you can go home now, just come back when the government again starts operating, okay? Well, you have a constitutional obligation to provide adequate representation to people charged with the crime. And if I can revise one of my earlier answers, I think one of the other problems Bobby Kennedy might have today is it's not just a problem for the indigent, it's also a problem for the middle class. Representing someone has gotten so expensive now that unless you are in the very high brackets, even people who are just middle class, the average blue-collar worker or low-level white-collar workers find it impossible to provide an adequate defense. And in some ways, they're really caught in the middle. They don't have the money the rich do, and yet they're not so poor that they can take advantage of the sort of people that you get in the Federal Public Defender Service. So you've got that as an additional problem. Structurally, whether or not you want to try to make incremental changes along this line or massive ones, those are, you know, political calls that I probably have no more expertise on than anybody else. But some of these sorts of problems might be things that you could at least try out for a while to see if it works and then be able to get the funding for it as it goes.
Thank you. Some thoughtful and provocative suggestions. So coming back to you, Judge Blake, first of all, any reactions to comments that have been made about structural issues, but also kind of segueing into what the role of the judiciary ought to be toward the defense function?
Sure. Well, taking the second part of that first, and as long as the Defender Services Committee does continue to exist, I think that we all, and we have at least one other member of the Defender Services Committee here, I believe, Judge Kessler. We believe that our role is to protect and support the excellent defender and panel attorney system that we have in place. I think that we have a role in advocating for resources, trying to be of assistance to our Defender Services Office staff is wonderful, and they try to learn the offices and be of assistance to them across the country. And there's a lot that we can do. At the same time, I do need to say we are managing taxpayer dollars. We need to do that responsibly. That's an important part of our role as well. At the same time, keeping in mind the independence of the defense function is critical. I'm not going to comment on any of the specific, very interesting proposals.
I'm shocked.
That have been tossed out. But this is a great opportunity to mention and thank the Chief Justice for his recent appointment of a new committee. I think the Prado Committee was mentioned earlier this afternoon, and I don't know if this will be the Cardone Committee or not, but one of our judges, Kathleen Cardone, is going to be heading up a committee of judges, of academics, of public defenders, a panel attorney, representatives from the field of prosecution, practicing attorneys as well. I think we have a great committee. They are going to be holding hearings. They'll be staffed well, I'm sure, and they're going to be holding hearings and considering many of these very issues over the next 18 to 24 months. These are critical questions. They're very important questions. I don't know what the recommendations are going to be, and as we've already heard as well, I mean, regardless of what the recommendations may be, some of them may be accepted and some of them are not, but it's a great opportunity to revisit questions of independence, of reasonable compensation, of equitable treatment of vouchers, of being able to obtain enough expert and other services. I mean, there are just a host of issues that will be great if we can find a way to do it even better than we are now.
Thank you. Tony, reactions?
No, not so much a reaction. It's just sort of an...
You had that look on your face of, oh, I have a reaction.
Not really. That's just my New York way about it.
Gotcha.
But, it's a fabulous system. And so great care and time should be devoted towards making it better. I've served on a couple of the committees in Washington for several years, and I've always found interacting with the Defender Services Committee very engaging. I've found that the judges are very interested in what we do. Many just don't know. Mm-hmm. They've never been defense lawyers. They've never been defense lawyers who've represented the type of indigent defendants that we represent. And so they've benefited from it, and we've done well. But we can do better, and we should do better. We have to be very careful about when, though, the judiciary goes from managing the public interest to being involved in the defense function. Because I can tell you, as we sit here this afternoon, United States attorneys are filing motions in district courts weighing in on whether a defendant should get services under the Criminal Justice Act. And there are a couple of district court opinions where the courts have taken the views of the prosecutors and ultimately deciding whether or not services should be rendered to an indigent defendant over the recommendation of the attorneys who have the ABA function and the constitutional duty to represent the defendant. And so this is why the Prado Committee, the new examination of the panel will be great, because it will provide an opportunity to see what works and what doesn't, and to tighten up what we have to do. So if that's the look on my face, that's what you're doing.
Excellent. Thank you. So we have several minutes. I'd like to open it up to questions, reactions. Not only do we have a distinguished panel, but we've got many distinguished people out in the audience. So we have a mic, I think, somewhere. Yes, in the back. And if you have reactions or questions of any of our panelists, please don't be shy. I know we have a bunch of shrinking violets in the audience here. Anybody? Yes. If you could just tell us who you are and where you're from, and wait for the mic.
Hi, I'm Christopher DeRocher with the American Constitution Society.
Welcome.
Thank you very much. Thanks for having this, and thanks for allowing us to participate as well. The question I had is, a lot of discussion has been had about how the federal defenders are the gold standard, but then we also talked about sequestration, and I think a lot of people who were in the trenches at the time that sequestration was threatening the federal defenders were really concerned with the viability, the continued viability of the federal defender program based on those cuts. And as you mentioned, Judge, it wasn't necessarily intentional. They were sort of the unwitting victims of a larger political struggle. So is there a way to insulate the federal defender program from that sort of the whimsical nature of Congress, given that this is a constitutional function that they're involved in? Thank you. Judge Blake?
No, that was a question for someone else. The short answer, I think, is no. Nothing that immediately occurs to me. I think there are steps we can take. I think we can try for predictability and stability in funding. I think we can look within our own system. For example, we've been going, as many of you know, through a work measurement process, a process of developing a new way of staffing and figuring out the staff for federal defender offices, and we don't know exactly how that is going to come out, but many people, including many people in this room, have worked very hard to try to make it what I think will be a good result. One of the issues of implementation is to look at stability, predictability. How can we, subject to the fact that Congress, may decide to sequester us again, how can we assure as predictable a stream of funding as possible? So I think there's things that we can do within our own process, within the administrative office, within how we handle our budgets. And I think that our court, I think our judges generally do a very good job, and our staff advocating with Congress, but to completely insulate us from Congress's many difficult issues. I'm not sure that I have an answer to that. Maybe someone else does.
Well,
Please.
The one thing that I've learned in life is that the more educated people are about what they do, the more informed they act. And a part of the process is just to continue educating the policymakers about the importance of what it is we do. And oftentimes that process results in change. When the avenue of education is cut down, when decisions are made on the basis of political ideology versus what are we doing day in and day out within the justice system with criminal defense representation, I think we get a better result. And so I don't know the mechanics of how these things happen, but educating policymakers has to be at the core of that. The more we learn about whether or not other people's constitutional rights are important as ours, that happens through education. So I would think it should be an important part of what we do.
Thank you. Paul?
Let me just make 3 points in this regard. One is, I know the federal government considers a variety of different types of personnel essential, as I think I mentioned briefly before. I don't know to what extent they consider the defense function essential. It should be. I mean, after all, it's constitutionally required. You can't go forward with the trial without it. And if not, then what you need perhaps is somebody to bring this to the attention of the Attorney General, to ask the new Attorney General to consider this as part of that whole issue, to make sure that regardless of how she defines the necessary positions in the other parts of the government, whenever there is a constitutional requirement that certain services be provided, they must almost by definition be essential to the effective running of the government. Second, I suppose one way to do this would be, in essence, to try to figure out how you could, and I hate to use this term, create the effect of an entitlement, if you will, so that what you have is funding that would be guaranteed for all constitutional functions that the government has to provide. I mean, there are very few things the government has to fund. It has to pay the president, it has to pay judges, and otherwise there really isn't anything they have to fund. Well, they have to either fund or provide an in-kind form of representation if they want to continue to prosecute cases where someone might wind up in custody, because the Sixth Amendment requires that. So you have to probably figure out some way of trying in the substantive law, like 3006, to deal with this in such a manner so that the funding becomes less discretionary and more requirement. And finally, just as a practical matter, I think one of the things you need to do, given the way politics and policy works today, is persuade as many prosecutors, former prosecutors, as possible to talk about the importance of making sure that there is adequate funding in this regard. The more prosecutors you get to say it is critical to have quality defense lawyers, the more weight your argument carries. It just as a political matter does, and it also becomes more persuasive to the average person who isn't educated in the law and how the system works, or who may not care about the politics of Washington. But if you have people known who are prosecutors saying this is critical, people who are non-experts in this field will recognize, therefore, that people on opposite sides of the courtroom must agree that this is critical, and therefore I probably should too.
Great, thank you. Terry McCarthy, you're the, I say this respectfully, the elder statesman here. You've been doing this job a long time. Reactions to anything that's been said?
Yes, two of the things Paul said earlier, and I think he's one of the brighter people I've run into, but I take minor disagreement with. The first one's a quick one. We don't need or want a Solicitor General, Paul. Believe me, we do a hell of a good job within our offices. We cooperate on it. Our office down in Tampa, I was down there with them at the time, they just won the big fish case, you know, and did a hell of a job on it. But our office has done very well. We've had several cases in the Supreme Court in my office since I've had it, and I think we do every bit as well as the Solicitor General, to be honest with you. But anyway, that's number one. Number two, and this will shock you all, and most of you will initially disagree, but I'm going to give you a hint that will get you over several of these hurdles. Paul mentioned the problem of the guy who's, you know, has some wealth, but he can't afford an attorney at the terrible prices that the attorneys charge today, criminal defense lawyers in the federal court. And he said that's a problem. Believe me, that is not a problem if, and this is my clue to you now, if you start using the correct terms. Get rid of the term indigent. Indigent does not appear in the Criminal Justice Act. It was purposely omitted. Get rid of it. And yet, and I read the Criminal Justice Section magazine, and here's these great lawyers from around the country talking about the problems of indigent defense. And everybody uses the term. It's been used here probably a dozen times today. It's not indigent, gang. That's not the criteria. The criteria is, can this person afford counsel? And that's the criteria. There's a far cry from that criteria, a very wise one, I might add, and the term indigent, the misnomer term. If you get rid of indigent, you'll get rid of a lot of problems, gang.
Thank you, Terry. Other reactions or questions?
Many years ago, my name is Henry Hetcore. Benjamin Franklin once made a comment that a penny saved is a penny earned, and the government currently deals in trillions. And the sequester was merely a method to reduce the great costs of these operations and try to reduce the deficits that we're facing. Every taxpayer has to worry about this. And frankly, I can't see dropping the term indigent from the rationale for providing a defense. I think there's something in it. To expand the number of people that would be able to get a court-appointed attorney without their cost, somehow they feel they can't afford it or get a loan to cover it, I think is wrong, in my own opinion. I wonder, what are your plans in the future, say in the next several years, if we're still running $1 trillion deficit per year, to cover costs? Where will this lead?
Thank you.
If I could just respond
Sure, Terry,
briefly. Go ahead. The word indigent is not to be found in the Criminal Justice Act. Matter of fact, it was specifically and intendedly omitted. If you look up the word indigent, you will find that what it means is somebody walking down the street begging for money and selling pencils. That's what indigent means to most people. And the act provides if you cannot afford counsel. And that's where it should be, darn it.
Thank you. Judge Blake?
One thing I would say about that, and I absolutely agree that the proper term is not indigent, it's whether someone is financially able to afford counsel. But I believe that there is a system in place, certainly in our district, and I assume this is the case generally. There is a financial affidavit that is filled out, and people are asked under oath about their assets and employment and what they may be able to afford. And the issue is, as Mr. McCarthy said, that unfortunately there's a very large number of people in our community these days that simply don't have the resources to pay what a private defense counsel would charge, and yet they find themselves in federal court facing all the resources of the federal government on the other side. So I think it's very important that we do look at the reality of what someone can afford to pay when they find themselves in this situation. The other thing I'd say, of course, the federal deficit, and I mean, it's a problem for all of us. amount of any deficit that is attributable to the courts generally or to the federal defender function is very, very, very small. And I think Congress, one of the reasons that Congress has treated us well over the years is because we have made an effort to responsibly manage the budget and costs and look at areas of cost containment, cost management that we can engage in without undercutting the quality of representation.
Thank you. Yeah, Tony.
And, I think that, good question is raised. I mean, as society goes through its changes, what's going to happen with the Criminal Justice Act?
Yeah.
Well, I think what's going to happen is that you're going to still see people performing a high quality of legal representation to people who are in trouble. And I do Criminal Justice Act work. I pay taxes. And it's a well-valued expense. It's a part of the great society that we live in. And so I think that we're going to continue to see attorneys come into the system who are going to be motivated to perform a high level of representation. I think we're going to continue to see outstanding judges and outstanding prosecutors. And I think we're going to have a continuing obligation to fund that. And we'll do it. And we'll do it in a combined effort that allows us, what Judge Blake was saying. And many of the districts, the CJA panels are involved in good practice techniques and circulating memos as to how we can save money. This dialogue goes on all the time. It's just as Paul pointed out in his initial remarks, the public doesn't know about that,
right.
that effort takes place. So we're going to continue to work hard. That's what we're going to do.
Thank you. We have time for one more. Yes.
I guess I want to put a pitch in for holistic defense work, and I'm from Oregon, so maybe I came the furthest out here for this panel. I think it's really important that as a defense system, we look at our responsibilities in terms of a continuum of care, whether it's the prosecution, we're not in silos, defense function, court function, probation, pretrial, and prison. So what we don't do in the courts sometimes lands as a burden to the prisons. What we don't do in a good job in holistic representation as a criminal defense attorney ends up with the person recycling right back in and going to prison, which is our highest and most expensive resource. So what I would tell you is one of the concerns I have is whether we level up or we level down. There are offices I'm aware of around the country that never ask for a voucher, never ask for an expert, never ask for the resources to do the kind of investigative work that will save time and money. And then there are offices that are doing holistic practices and getting ahead of it and solving problems and ending up with shorter sentences, supervision that's meaningful, and services. So there's a holistic part. And as we go forward, I hope we will look broader at what the functions are and what we're doing to change the cycle of crime involving children and families and breaking that, because frankly I'm really tired as a taxpayer paying for prisons and now paying for reentry centers that are merely baby prisons and then having people fail the baby prisons and going back to the big prisons because we didn't get adequate services. So I would ask each of you to talk a little bit about what does it mean to be a defense attorney, and are we going to hold them to just filing papers and appearing in court, or are we going to deal holistically with explaining to their families what's just happened and how they can be supportive and how they help people on reentry, coming back and being successful? Are we going to involve them in the process, or are we simply going to be so linear that we really cut our vouchers, but maybe not cut our losses in terms of the overall correction costs and costs to the system and families generally?
Thank you.
But one, I can't help but add it. Maybe and soon we'll even get experts on hair in the federal courts. Yeah.
Well, I think that's a great question. I was asked, I think last week, Tony, what do you see as the future as in Criminal Justice Act representation? Now, I don't use the word holistic, but I'm right on point with you. We've gone from a system where defense lawyers tried cases to a system where we plead cases, where sentencing has become the center and core of federal practice. But in sentencing, the Supreme Court liberated the courts in the Booker decision. And so what I think one of the great challenges of CJA counsel in the future is educating the courts as to how the sentencing regime destroys communities and families and does not reach the goal of Congress to impose a sentence that's sufficient but not greater than necessary. Judge Weinstein wrote a beautiful opinion in a case called United States versus Bannister, where he took on just what you're saying. He looked at the continuum of what it is the prosecution was trying to do and what was the role of the court in setting punishment, and then took into consideration the family, the community. It is really a remarkable decision, and I think it's a tremendous responsibility post-Booker on defense attorneys to begin to bring to the court information about the background and history of the offender. Where did those communities come from? How did this criminal activity come about? And what can the court do to intervene to change that other than warehousing people, which is the great shame of this era that we live in?
Thank you very much, Tony. And we will have to leave it there, but that's a great place to leave it in preparing for our next panel. Can I thank, can we join me in thanking our current panel?